The International Criminal Court, the ICC, has 123 member countries worldwide, including 33 African states. Its authority comes from the Rome Statute, allowing it to exercise jurisdiction over 4 main crime categories. These include genocides targeting national, ethnic, racial, or religious groups, crimes against humanity involving acts like murder, rape, enslavement, and torture, war crimes such as using child soldiers and attacking civilians or historic sites, and the crime of aggression involving armed forces used against another state's sovereignty.
Africa can make a difference.
The continent played a significant role in establishing the ICC in 2002.
I welcome the suspect, Mr. Ntaganda.
However, in 2017, the African Union urged African states to cease cooperation with the ICC in executing warrants for the arrest of African suspects and to withdraw from the court. The Union accused the ICC of unfairly targeting Africans and labeled it as a neo-colonial court. Charged with crimes against humanity, notable figures like Laurent Gbagbo, the former president of Cote d'Ivoire, Uhuru Kenyatta, the president of Kenya from 2013 to 2022, and the incumbent President William Ruto, Omar al-Bashir, sitting president of Sudan at the time. Among the 31 completed cases, only individuals from African countries have been convicted.
The United States and other European countries like the United Kingdom have been involved in what you could say are war crimes or even crimes of aggression in countries like Iraq and Afghanistan. And there have been no prosecutions by the ICC against even heads of state of those countries like George Bush or Tony Blair, who are cited as having not proved that there were weapons of mass destruction, for example, in Iraq. Also in Libya, where we saw these big powers invading a sovereign state and ultimately really leaving those countries in greater instability than they were before these invasions.
However, it's important to note that many other cases were referred to the ICC by affected African states themselves.
It seems like it's a catch-22 situation for the ICC, where on the one hand, they are seen to be these busybodies who engage and undermine the sovereignty of states, while on the other hand, others argue that they are not strong enough to ensure that impunity does not carry the day.
In Ukraine just 3 weeks ago.
Some states propose replacing the referral power by the United Nations Security Council with the UN General Assembly, which includes representatives from all the UN member states. This to establish a more inclusive decision-making process when determining whether ICC examination is necessary.
Of Russia's unprovoked, full-scale invasion.
The court recently launched an investigation into Russia's invasion of Ukraine in 2022 after a referral from over 40 member states. A warrant for head of state Vladimir Putin was issued in March 2023. South Africa will be hosting Putin during the BRICS summit in August this year and will be obliged to detain the Russian leader.
The ICC and the Rome Statute are consistent with our constitution. And therefore, a narrow view of this would say that the national interest says, therefore, that in order to curb impunity, South Africa should arrest Vladimir Putin. But on the other hand, there's an argument that is made that in the national interest, it is not wise for South Africa to really consider arresting Vladimir Putin. And this is really because of the diplomatic relations between Russia, but more importantly, the relations that South Africa has as a member of the BRICS. Through institutions like the BRICS, the position in geopolitical terms of the global South can move away from subservience towards really taking up a new position of dominance and resoluteness in the global politics. The BRICS is playing an important role in changing this global governance about who gets what, when, and how in a position that really begins to benefit the global South.